Welcome to the People's Law School. Ladies and gentlemen, tonight you're in for a treat. We get 3 for the price of 1. We have Huntsville's own, the lawyers of Warren and Simpson. And I will tell you that I've known all of them for a long time. And first I want to tell you that the last speaker will be Fred Simpson. Fred Simpson's a lawyer around Huntsville. He's an icon. He has practiced law for 40 years. For 13 of those years, he was the district attorney, and he's cut a wide path. What you don't realize is that Fred is also an artist. He's a legal historian, and he's written many books. Sometimes when you see this program on TV, the 2 million people that get to watch it throughout the state, some of the pictures that air on it were drawn by Fred, so he can do a lot of things. Great trial lawyer. I will tell you the second speaker will be Derek Simpson, his son. Derek, I will tell you that Fred went to Samford University and then on to Vanderbilt. I find it interesting that his son Derek, also a great lawyer, graduated from the University of Alabama undergraduate degree and also University of Alabama law degree. And since I did the same thing and being a University of Alabama fan, I will tell you that that just goes to show you that what a man who's been in the business 40 years thinks where a person needs to go to law school. Our speaker and also their partner, Barton Warren, graduated from Samford University and the Cumberland School of Law. And I will tell you that their law firm in Huntsville is one of the best. They've achieved extraordinary successes and verdicts in all of their negotiations and settlements. And I want you to know if you're against them, you better hang on because you got your hands full. It is my honor and privilege to present to you the law firm of Warren and Simpson. I believe, Barton, you're going to speak first, and thank you so much for coming.
Thank you.
Good to see you.
Good evening. We're delighted to be here with you tonight. Alan, thank you for all you do here with the People's Law School. This is a wonderful program here for our city, and I commend all of you for attending and being part of this great program. When we were here last year, we devoted a lot of our discussion to how to prove a case of fault, how to prove a case of liability when someone has been injured due to the fault or the negligence of another. And we focused primarily upon use of expert witnesses, product liability experts, DOT experts in the trucking industry. Our firm typically handles catastrophic injuries that have been suffered by individuals due to the fault or negligence of another. What we're going to talk about tonight, at least I am in my portion, is once fault is established, then we go to the second portion of the case, and that is what we call the damages section. How has that person, that victim, been injured? How has it affected their life? And then from the jury's perspective, what is reasonable and what is fair compensation to that person for these injuries that they have sustained. One of the things that I have brought with me tonight is a book that is on every table and bench of every judge in the state of Alabama. This is the Pattern Jury Instructions. And within this book are the rules of law that the judges read to the juries once the case is over to instruct them on the law that must be applied. And typically there are 5 elements of damage when one is injured due to the fault or negligence of another. Number 1 are the medical expenses. Number 2 are the lost wages, both past and in the future. Number 3, the physical pain and suffering. Number 4, the mental anguish, the worry. And then number 5, if the injury is permanent, compensation for that permanent injury. Now, when we're presenting a case to a jury and we're presenting the medical bills, we put in the medical bills. That's a number really that's undisputed. When we put in the lost wages, we can bring in, say, an HR director, and we bring in a W-2 or a tax form, and we show off-work slips from the physician, and we just calculate the number of weeks missed by the wage earned, and that's our lost wage claim. Those are fairly simple computations that all of us can perform with a simple calculator. But I would ask you to give this some thought right now. Have any of you, say within the last year, been asked to compensate someone for their pain and actually fix an amount? It's a difficult concept to think about, because our body is not set up or equipped to endure pain. Our body doesn't function well when we're in pain. We go to the doctor to try to get relief from pain. We go to the pharmacist. We stand in line to get the medications we need to relieve these ailments that bother us if we are in pain or discomfort. But what if someone is injured due to no fault of their own, and their body is just riddled with pain that affects every walk and every day of their life? The law says they are to be fairly compensated for that. And when the judge instructs the jury on how to do that, here is what he tells them. Ladies and gentlemen, the law has no fixed monetary standard to compensate for physical pain and mental anguish. This element of damage is left to your good sound judgment and discretion as to what amount would reasonably and fairly compensate the plaintiff for that physical pain and suffering. Now that's it. Now, that's the only instruction the judge gives the jury. And I want you to visualize a moment that jury of 12, men, women, old, young, highly educated, high school educated, rich, poor, employed, unemployed, retired, maybe fresh out of school. You have 12 different people from total backgrounds that are just completely different. You have one juror that may have $5 in their pocket for lunch that day. You may have another juror with a wad of $100 bills in his pocket that he carries all the time. And their concept of money and dollars is different. But all 12 must come together in that jury room to reach a unanimous verdict on what will be fair and reasonable. Now, the other thing the judge will tell the jury, that it is for you, ladies and gentlemen of the jury, to determine from the evidence the nature, the extent, and the duration of the plaintiff's injuries, the person who's been harmed. If you are satisfied from the evidence that the plaintiff has been injured and the injuries are permanent, you should return a verdict which you feel is reasonable compensation for such permanent injuries. Now again, there's no math formula, there's no calculation, there is no sliding scale given to those jurors on how to compute these forms of damages, although the jury is told you should. Now, what I'd like to do for the next few moments is give you some examples of how we go about proving the extent of physical pain and suffering, mental anguish, and permanent injury, so we can equip those jurors with information so they can make a logical decision that is both fair and reasonable to both sides. One of the things we do is we will be calling doctors to describe the injuries. We have, I guess, every body part in a skeleton that we have in our office. We have ankles, knees, elbows, hands. And depending on the type injury we're handling for this particular client, if it's a spinal cord injury, which many times we see in 18-wheeler wrecks, motor vehicle wrecks, bad falls off construction sites, there will be some injury to the spine. It could be a fracture of a vertebra. It could be an injury to one of the discs or the shock absorbers that then pinch one of the nerves and cause the leg pain. It could be a broken pelvis or hip area. But we would give this to the doctor when he is testifying and ask him to describe for the jury the anatomy of the spine, what all these different parts represent, and then take this model and show for us what actually happened to our client in that accident to cause those injuries. Another method that we have used are medical drawings. There are groups of artists that are also trained as nurses that can take x-rays and operative reports and take a true x-ray such as this and then diagram for us what actually happened in the body. So when the doctor comes in to testify, he can describe what actually happened to this particular client. This young man that we represented in this case had been working up on an elevated surface at a construction site. OSHA requires there to be certain barriers, ropes, tie downs, things of that nature when you're above 6 feet. This contractor didn't use those. And when he was working on the edge of one of these buildings, one of his co-workers accidentally bumped him and he fell off. This was the condition of his spine when he got to the hospital. It fractured his spine and actually severed his spinal cord, and he was paralyzed from the chest down. Now, one of the things we wanted to illustrate was what the normal spinal cord would look like, and then what happened to this young man's spine due to the fall. One of the interesting things about this case is surgery was actually performed in the case. And when the surgeon was testifying, I asked him, why did you perform surgery on this young man's back knowing that he had a severed spinal cord? Could it grow back together? Could you make him walk again? He said, no. This was not to restore the function or the ability to walk. It was to allow him to sit up straight in his wheelchair. Now, the next one that I wanted to show you was a young lady that was involved in a tragic 18-wheeler wreck where an 18-wheeler pulled out in front of her and she collided with her steering wheel. This was taken straight off of her x-ray and interpreted by the nurse illustrator, and you can see here where it cracked her jaw and broke her teeth. Now, this is what the oral surgeon had to do here to actually wire the mouth back together so she could have, the bone grow back together and so forth. Now, dental work was required much later on. But by the time we got to trial, all of this had healed. And we wanted that jury to understand the severity of the injury, the fact that she could not eat for weeks and weeks and weeks, had to drink out of a straw. Again, the suffering and the mental anguish and the worry. And what better way to illustrate that than having a drawing like this to depict that? Oftentimes we encounter injuries where the physician has to go in with plates, rods, screws to perform an operation. This young lady was also involved in an 18-wheeler accident. And when we got her films and her records in, there were broken bones in the arm that had to be repaired with plates, screws. The femur was broken, an entire rod placed between the hip and the knee. Also, you see here down by the ankle and the foot. Now, obviously, when she is with us in a courtroom and she's dressed, we don't want to make anyone feel uncomfortable by pulling clothes up and things, but when we show this to a jury, they can understand what our folks go through. The next one I want to show you is a brain injury. This young man was severely injured in a motor vehicle wreck where he was run off the road by a drunk driver. The CT scan of his brain showed these spots, which are internal bleeding areas, hematomas. And one of the things that we were hearing from the family was that memory is not right. He's forgetting some of the things that he should remember. He's not responding correctly to jokes that are being told. He doesn't smile, or he does laugh inappropriately. And when we had this illustration drawn and the doctor could explain in the frontal lobe what these portions of the brain control, it explained those symptoms the family had told about. One last one that I'd like to show you. is a femur fracture. This was a young man involved in a bad wreck in Coleman, and it snapped the femur bone in his leg. And when I was questioning the doctor in trial about this rod that was placed, one of the questions we asked was, how do you put that in? What are the surgical tools? What are the instruments used? Because I would venture to say, unless someone here is a nurse or a doctor, very few of us have ever seen an operation. We're all, if we're in the operating room, we're asleep. But I asked the doctor, I said, assume right now that the jury's with you in that operation and they're standing against the wall and they're watching. What would they actually see you do? And he started describing, as he put this in, that there's actually a big drill bit. It's called a reamer, that you drill out essentially the bone marrow. And then this rod is placed in with a mallet. And then stainless screws are put in here with a screwdriver. But these are some items that we have used to be able to illustrate to a jury the extent of the suffering and the discomfort and the permanency of some of these injuries that our clients have come to us asking us for help. I want to save plenty of time for Derek Simpson and his father. It is an absolute privilege being able to go to work each day with these two fine men. They are the top of the legal profession. And it's a pleasure to introduce Derek now. He is a true communicator. He works harder than any lawyer I know and does a tremendous job here at our firm. And I'm proud to be his partner, and I'd like to turn it over to Derek.
Wow, he said that just like I told him to say it. So nice. I tell people all the time how truly blessed I am is that I truly get to work with two of the smartest people I have ever been around. First is my father, and then of course Barton. Not only are they the smartest people I know, but some of the best trial lawyers I've ever been around. And for him to say something like that is so kind. I got to tell y'all a story about me real quick, a story that's on me. When I was growing up, as a kid, I used to always like to go watch my dad try cases. And I would go in the courtroom when I was 8 or 9 years old, and I would sit from beginning to end. And the very first trial I ever went to, the judge was talking to the whole venire. And if you've ever been on jury duty, when you come in and you'll sit with like 30 or 35, and the judge will start asking those 30 to 35 people about the case. And this was a murder case. And he said, now, folks, this is a murder case. Does anybody know anything about the facts of this case? Well, I thought he was talking to everybody in the courtroom. And I said, well, my dad last night told me all about it. So I raised my hand. I said, yeah, I know about it. Sure. And then, nobody said anything. He says, does anybody know Fred Simpson, the DA? Is anybody in here related to the district attorney, Fred Simpson? I was like, I am. It's my dad. So anyway, there was a conference up at the bench, and my dad turned around and looked at me, and he walked over there, and he said, hey, they're not talking to you. They're talking to these people. So that was the very first time I was in a courtroom, which was a long time ago, but I've always been kind of interested and enamored by what happens in a courtroom. And when you think about a jury trial and think about the logistics of bringing just random people, and the only common denominator is that they live in the same zip code or the same county, it's pretty amazing. And these random people will come and hear a case that cannot be decided between the lawyers, and normally the juries get it right and decide big, big issues. Not only life and death issues, sometimes in criminal cases. And if you step back and think about our system that we have, it's pretty amazing. And I've always been pretty overwhelmed by how that works. What Barton talked to you about was some things that happened during the trial. But before the trial starts, and I kind of went over this last year, but we have the voir dires where the jury comes in and you try to pick and choose who's going to be on the jury. I want to talk to you tonight about the opening. The opening, usually, by the end of the opening, the jurors, you have got a very strong belief about what the case is about. And I'm a strong believer in something called primacy. And primacy means is that once you get a belief in something, you're going to stick with that belief until the end. And that belief builds momentum until something halts or stops it. For example, in our cases, against 18-wheelers, if you're a truck driver and you are biased toward truck drivers or trucking companies, and we're sued a trucking company, when you come in and you're on that jury, you're going to have this inclination that everything we say is wrong and that we shouldn't be suing trucking companies. And you're going to keep that belief going until we try to get you to stop. And that's going to keep going, and that's called persistence. Persistence is that tendency to just skew everything kind of the way you want it to be viewed. Let me give you a perfect example. This basketball season, we're right in the middle of all the basketball season. I don't care about any of the basketball teams playing. Don't know anything about them. But if I sit down and watch one of those basketball games, and I don't care about either one of them, before that game is over, I am rooting for one of those teams. And I don't know why. But that's primacy. And that's the same thing that happens to jurors, that for whatever reason, you will start rooting for one side, and that builds momentum as the trial goes on. Now, not only will I start rooting for a team that I didn't care about when I sat down and first started watching it, but if my team gets called for a foul, I'm like, come on, are you crazy? It wasn't a foul, he didn't even touch him. You know, and that's the same thing in the trial. So, the opening is very, very important, because I believe by the end of the opening, usually jurors will have an ironclad belief about what the case is about. Now, how I start my opening is I normally tell the jurors what are the rules. You know, I have two little girls, and when we get a board game, they will rip it open and they immediately want to start playing. They start rolling the dice or whatever, and I say, hold on, we've got to know what the rules are. Who goes first? What is the objective of the game? Why are we going to play this game? They don't want to hear it. They just want to roll the dice. What's the same thing with what we have to do with juries, is I have to tell you what the rule is. And if we are there on an 18-wheeler accident case, I would say something like this. If you're going to drive a truck, you have to watch where you're going. If you don't watch where you're going and you hurt someone, you're responsible for the harm. That's a pretty simple rule. But everybody can relate to that. If you're going to drive a truck, you got to watch where you're going. If you don't and you hurt someone, you're responsible for the harm that you cause. And then I try to go from there to try to tell the story of what happened. And other lawyers do it a lot of different ways, and there's no right or wrong, but what I try to do is try to stick to one fact per sentence so the jury can follow me along. And it'll go something like this. March 30th, 2009. Mr. Simpson was in his car. He was traveling north on the Parkway. Clear night, roads were dry. He came to the intersection of University Drive and Memorial Parkway, and he came to a complete stop. He stayed stopped there and was waiting for the light to turn green. While stopped, he got hit from the rear. And he got hit with such force that his car propelled into another car. And then he felt his car turning over. And he felt glass cutting his face. He felt his nose being pushed in. He felt his arm going in a position that it should never go in. He felt his foot being crushed into the pavement. The person who that happened to is sitting here with us. They were introduced to you in voir dire. And that's what this case is about. Now, that's just a story. That's just a story of what happened. And all I'm trying to do is just tell you this is a story. I didn't point any fingers. I didn't put any blame on anyone at that time. All I said was, this is the story. Now, from there, I try to go into, well, who are we suing? I go into the blame. I said, well, why are we here and who are we suing? I'd say, well, we're suing the ABC Trucking Company and John Doe, the driver of the trucking company, for these reasons. And I'll lay those out. You know? And I'll lay out the reasons why we're suing, that you have to drive at a safe speed, that you have to look out for other cars on the road, and if you don't, you're responsible. And I lay out the whole reasons why we're here. And then what I try to do is I try to say, but before we could get here, before we can impanel this jury, we want to make sure some of the things that we're going to bring to you are correct. Number one is we went out and looked at the traffic lights, and we got a traffic engineer who said that, yeah, those traffic lights were working properly. We also went and looked at the brakes on the truck that caused the collision, and those were working fine. Now, with regards to the speed of the truck, we went and talked to some eyewitnesses and got them to write out statements for us, and they're going to come here and testify that he seemed to be moving a lot faster than the people on the parkway. And with regards to the injuries, we went and videotaped a orthopedics deposition who did the surgery, who's going to tell you that all of those injuries were caused by this accident. And every type of issue that comes up of why we're here, we try to explain what we did to get it here. And we try to leave nothing to chance. And then we talk about the damages. And this is where we really, because as Barton said, it's hard to put a figure on pain and suffering. But we talk about the injuries, the consequences, the nature and the extent and the duration of their pain, and the fixes that could help. You know, we'll say, you're going to hear Mr. Jones testify that as a result of this collision, he lost $18,000 worth of work. You can fix that in this case by including $18,000 in your verdict. And then I try to wrap up by telling them this, that everything we show in this trial is for you to see why Jane Doe, or our client, should be made whole in this collision. And at the end of this case, you're going to see why we have to come up and ask for it. And then we ask for an amount. Some lawyers say, nope, don't do it. But what we try to do is we try to ask for the amount up front. And jurors try to, I think, can hold on to that number, and then we prove that number as we go through. And that's the question I want to ask you guys. How do you feel about that? Would you like to hear a number in the very beginning, or would you like to wait until the very end? Because the case is about the damages. It really is. I see get some head.
I don't want to say wait, innocent until proven guilty. Prove them guilty, and then in your summary, hit them with the number.
Well, see how it's just a different. That's exactly what people say, and some people disagree. One of the reasons I think is that it just gives a number that we're not trying to hide anything. And in closing, we can say from the very beginning, this is what we asked for.
It's probably something the person on the jury keeps in their mind too.
Right, absolutely. Now, and then I'll sit down, and then the case will progress, and it's amazing that usually the case and all of the witnesses are about, from our side, the rules. If you're driving a truck, you don't watch where you're going, and you hurt someone, you're responsible for the damages and the harm. There's so many times in trial when the jury's there and there's a witness testifying, and I just want to say time out and turn to the jury and say, did you hear that? Did you hear that? But we can't do it. So opening is one of the few times that we get to stand up and say those things. Now, after the trial progresses, we come to closing. And there are people truly, I believe, that are gifted, truly gifted at giving closing arguments. And unfortunately, I am not one of them. But there are people that I know that are very gifted. And one of the persons that I think is extremely gifted at giving closing arguments is my father. And I tell them this all the time. The reason why I'm a lawyer is because he was so good at closing arguments. And as I was a kid, I used to sit through just hours and hours of just the most mundane testimony, but I'd wake up and say, but 2 more days and we got closing arguments. 1 more day, we got closing arguments. And it's those lawyers that can actually just wrap weeks and weeks of testimony up into a single thought or just something that they can grasp onto. And I'm firmly convinced that if you polled the jury before the closing argument and you polled them afterwards, I don't think a lot of their opinions would change about how they would vote, but it's in the jury room, and it's those jurors that are with you. And good lawyers in closing arguments arm their jurors that are with them. So when they go in there and deliberate, they say, yeah, but didn't you hear Mr. Simpson say this? What about when Mr. Simpson said this? Okay? Well, it truly is one of my greatest thrills to practice with Barton and my dad, but my dad is truly just a gifted advocate, and he is retired now, and I always try to get him to come out and try some more cases and help us more, but it's with great admiration that I introduce my father.
Both these young men tell you about what they do in court, but let me tell you that at our house, every Sunday after church we have dinner, and all of the family always come. But as soon as Derek gets through eating, he goes to work. He goes to work 7 days a week. If he's in town, he's at the office. And Barton does the same thing. And go down on Sunday afternoon, they're both down there working. And that's how they get prepared, and that's how they get up. They can get up here and tell you what they do in court and why they're so good at it. In closing arguments, it gives an attorney gets a chance to have heard everything in the trial, and then he gets to put his slant on what happened, or what he thinks happened, or what he can convince the jury of that happened. And it's my opinion that sometimes you can change the jury's opinion about things and get them to vote the way that you want them to by talking to them and pointing out things. I'm going to give you just a couple examples, but for instance, we have a murder trial, and the defense puts on a case that says this is a good boy, he's got a good old mama, and they put on 20 witnesses that says that he's just the salt of the earth. He's a good man. He's never done anything wrong. And how do you refute that? That he's never done anything wrong in all his life, but he's killed someone and he's on trial for it. Well, the counter argument for that is that you give an illustration that the victim family is at a family reunion, and everyone says, "Where's Bill? Where's the victim?" And someone says, "Well, he's not here. He was killed last year." And somebody say, "Well, who had a right to do that? What happened to that? Why?" And you'd say, "Well, that's okay. You can't talk about it. You can't do anything about it because he was killed by a man with a good reputation." And you counter arguments by, and for every good argument you got on one side, there's an argument for the other side. So you use things like that to try to convince the jury of what you're saying and what you're trying to prove. And Derek's talk about him closing argument. Did you hear him talk about just the opening? Can you imagine how he would go into closing argument? You can get real passionate about it and start hollering, and some of the best lawyers in the world holler at the jury and whisper and get over and look them right in the face and do all kinds of things. Anything to try to get them to agree with you. You're not the lawyer is not there for justice or for trying to prove anything but what his case is. And we have the best system in the world. Sometimes people complain about our system, but we have the best system in the world, the adversary system. If the truth is going to come out in a trial, or going to come out in anywhere, it's in cross-examination, and the skillful adversary of the two lawyers involved, and the judge is only the referee. So you object, and he says abstained or overruled or whatever. He's there to keep peace and try to get the trial to move along. Probably that's his job. But a trial is between two lawyers who are adversaries, and I can assure you that there's not any lawyers that has a friend in the courtroom. If I tried a case against Derek, I'd try to beat him because that's what you're sworn to do when you graduate from law school. All your life you're set to try to represent your client and do the best you can in the courtroom. Sometimes young lawyers in trying their cases don't think about the closing argument, and they have a person on the stand, and he's going to prove that he told a lie. So he's talking to the man, cross-examining the person on the stand, and he's got this transcript of a statement he made before, and says, so he gets a story, and the man's changed his story. So a young lawyer that don't know what he's doing would say, "But look, I've got this statement right here, and you said something different, didn't you?" And then all that does is give the person the opportunity to explain. Well, I was drunk that night, or I was confused, and here's the truth about it. But a person who's been in trial a good while will just ask the question and let him tell a lie, let him tell a different story, and then in closing, you bring that to the attention of the jury. You remember when he got on the stand and he said this, but here's his statement where he said something else. And he didn't have then the opportunity to tell the other side or to tell why he didn't tell the truth or why he told a different story. You understand? So you get prepared. Everything you do in the trial, from asking a juror in voir dire, if you want to sit on my jury, do you believe in this, or what's your opinion about that? Are you prejudiced about this? You're preparing for the closing argument, the summation of tell what the trial was about, and try to have your point of view prevail in the jury room. Once I had a case where a woman and a man was in a trailer, double wide, and this woman's story was that they were having dinner, and the husband said, "Go get me my pistol." So she walks up to the bedroom and got a pistol and started down the hallway and accidentally shot him. And he ran outside, and when the police got there, she had his head in her lap and crying and bailing and whatever. So what do you do about that? There's only two people in the trailer. How do you prove that there's something unlawful done? Well, what I did was to get a dummy from a department store, mannequin, and had the toxicologist that examined this person to drill a hole took a normal drill and drill a hole where the bullet went in and where it came out. Then I got a long metal rod and slid it right through there, and it was just straight. And then I put the death weapon, the gun, on the end of that rod, and when I put the woman on the stand, I asked her to come down and put her hand on the gun. And when it did, it was just up in front of her eyes, just like that. So you do things like that so that in the closing argument, you can say then, did you see her standing there? And she had known that she shot him and aimed because it was eye level. So you build all of your case, as Barton pointed out, the drawings and the demonstrations that you have. Each little thing leads to the summation, so you can tell the jury, the attorney gets the chance to tell the jury what he thinks about it, and they can tell you things that you didn't think of. And sometimes I've talked to the jury, and I will tell them things and point out something, and I can see them nod their head. Yeah, that's what happened, because they hadn't thought about that, but I did. I thought about it when I was working on the case last year before that. And you make the point, and the jury then understands and puts things together and agrees to return a verdict that you want. one thing that I'm sure you have learned is that there are all kind of lawyers. You hear one type of lawyer and other kind, but for the people that's watching television, I'd like to say, how do you pick a lawyer? How do you find a lawyer that is best for you? Well, one way, well, there's several ways, but if you just pick them out of the phone book, the best way is probably pick about 3 and go talk to 3 of them and see which one you like. But I think the best way is to, according to what kind of case you've got, if you've got a civil case, call a criminal lawyer and get him to recommend a civil lawyer, or call a criminal lawyer, get him to recommend a civil lawyer. See, so they're not competing with each other, and different lawyers do different things. Administrative lawyers who handle things like Social Security claims or real estate. They do paperwork. And then they are civil lawyers, like my son and Barton. That's a civil practice. They handle money cases. And I spent all my life as a criminal lawyer. And then there's a difference in people who spend most of the time in the office, and then there's those people who are called trial lawyers. And trial lawyers are a different breed altogether. They ought to be on the stage in Hollywood or someplace because you have to be kind of a showman in order to get up in front of people and say things and try to convince people of things and put on kind of something that's interesting so the jury doesn't go to sleep. So there's all kind of lawyers, and you have to select one that fits your problem. If you have a problem, there's a lawyer that can handle it. I've enjoyed immensely the practice of law, and sorry that I had to quit, but my health got so bad I couldn't work anymore. But it is a great profession, and you would think that maybe a minister would help people, and so you would want to be a minister so that you could help people, but a lawyer can do things that nobody else can. There are people that came into my office during my time, and they come into every lawyer's office, and they start talking to you and they have a problem. And it doesn't matter what their story is, what they're asking you to do is take the problem off their shoulders and tell them it's going to be all right, so they can go home tonight and get a full night's sleep, because they hadn't been sleeping because they've been worried to death about this case or whatever it is. And unfortunately, you have to tell them, I can't tell you what's going to happen with the jury. Who knows what 12 people might decide? Who knows what the evidence might be? And it's heartbreaking to tell people that you can't tell the future about what's going to happen, because they want so much to be relieved of the worry. But you get to help people. If somebody needs help and don't have the money, that's okay. You still represent them. There's a lot you can do for people as an attorney, and speaking to people that watching on television, everybody that can, you should recommend to your children that they explore law school, because it's a great profession. Now, Ellen has always allowed me to quit talking and answer questions. Sometimes people have questions that you want to ask, and I've been at it 40 years, and I'll try to answer the questions if you have one. Does anybody have a question you'd like to ask about the practice? No? Yes, ma'am?
This is sort of unrelated, but do you believe that great oratory skills that you possess and your son possesses and Barton, his last name possess, do you believe that they can be learned, or have you just accumulated them over time?
I think that it is like Alan said about my drawing ability. I was just born with it, and I just think there are people that can get up in front of a crowd and talk, and they're good at it. And I think it would be very difficult for a person that's shy, for instance, to learn how to hold forth in front of a crowd. But politicians and lawyers are just love it. So, and they're born. I think they're born with it. I don't know that it. I don't know that. I guess you could learn it, but again, if you're backward and shy, and I've seen people get up in front of a crowd and just stutter and cannot talk. They're just scared to death. So to answer your question, I think you're born that way. I don't know that you can learn to speak that will convince people. Yes, ma'am.
What does it mean when a case is no process?
Now process is in all my life, and when I started law school, they started talking Latin, and I just tried not to listen when they talked Latin because I didn't understand what they were saying most of the time, and I tried not to ever use Latin in the courtroom or to people. But non pros simply means it's dismissed. But non pros does not mean that you are forever free. That it means that the state does not want to proceed at this time, but they can bring it up later if they want to. And a good lawyer, for instance, when they will say, "Let me non pros," and the good lawyer would argue with it, start talking to the judge about dismissing the case on the record that it's dismissed, because a non pros simply means that we don't want to prosecute it this time. It can be brought up at a later time. But again, I just try not to ever talk Latin, just those kind of words. Yes, sir.
Could you tell us a bit about one of your more memorable cases from your tenure as district attorney?
Well, I had so many. I tried when I was district attorney. I tried 63 murder cases, and so there was a lot of them. I had some memorable cases that some of you might remember. The Southwest molester, for instance. How many of you remember the Southwest molester? I tried just about anything any murder case in the 70s I tried. And some of them are heartbreaking and some of them are very entertaining. And believe it or not, some of them are so hilarious that you have to drop your pencil and get down under the table to find your pencil because you laugh out loud. And some of the things they say on the stand and the things that goes on in the courtroom, but sometimes it's pitiful. Sometimes it's just such a tragedy. And somebody died and somebody really don't need to go to penitentiary, but that's the way the world is and that's what happens. But I'm trying to think of what the best one, most interesting one, like that when I was telling you about the girl and the mannequin. I always had to think of some way to convict people, and then remember I was only 12 years as district attorney and I practiced 40 years, so most of my life I've been a defense lawyer. And I was blessed that the last years of my practice, I practiced with my son, and we tried, I think it's 13 murder cases together before I retired, and we had a good time, and it was greatest thing in my lifetime, and I got to practice or try a case with my son. But one of the last, I think the next to the last case we tried was a man from Barbados that came here and met a girl from Barbados, and they got married. And strangely enough, women in Barbados it's kind of a custom there that the women will have a baby, get support, and then ditch their husband and get another one and have another baby and get support and ditch that one. So that's what happened in this case. She got pregnant and had a baby, and she didn't want him to see the child. And when he'd go to the house to see the child, she'd always give him fits and cause him problems and the like. So he decided to leave town, and he cleaned out his apartment and only had a few items left. And a neighbor had come over and was going to buy his couch. It's about the only thing he had left. And in walks his wife with her sister and another girlfriend. And they came in and started berating him and cussing him and the like, and they had box cutters. You know what a box cutter is? A razor? Well, they had box cutters. So this man was so afraid of this woman that he had gone and out and purchased a gun and a bulletproof vest. And that was in his apartment. So at any rate, when she tried to cut him with that box cutter, she grabbed his shirt or sweatshirt or whatever, and he just came out of it, just pulled it right over his head. And he went in, just walked into the bedroom and got his gun and came back and shot both of them, killed both of them. And the bullet from one of them hit the girl's hand and damaged the box cutter, and in turn it hit her. So the bullet hit a box cutter that she was holding in her hand. But anyway, that was a death penalty case. They were going to kill that man for that. And my son and I went to Barbados and took a home camera and set up on the beach and neighborhood and wherever, and took statements, like I was saying a while ago, good reputation. I got about 97, I tried to get 100, but I had about 97 people that testified that this was a good man. He had represented Barbados in the Olympics and track, and he had never given any trouble. And I had the man that was there in the apartment trying to buy the couch to testify about what happened. And we had offered before trial, as we were trying to settle the case, as we always do, and offered to plead him guilty to manslaughter and time served so he could get out of jail and go back to Barbados, and the DA wouldn't do that. So we tried the case, and to everybody's utter amazement, he was found not guilty. But it was because of what we did, like Derek and Barton does. You work 7 days a week. You fly down to Barbados and take your trusty home camera and take movies of people saying he's a good boy. You go investigate and look up people. And you're out at 8 or 9 o'clock at night in the project or somewhere like that or anywhere trying to find a witness, or go to Cleveland or New York or whatever to find a specialist. Whatever's needed, you have to go do to try to get ready for your trial. And that's what successful lawyers, that's what they do. And they investigate. Every good lawyer is an investigator, a good investigator. They have to be. And that's how you win cases.
Fred,
Yes, sir.
we have time for about one more question.
Okay.
So I'm going to ask it. And I'm just curious, even though I met you 39 years ago when I got to work for the district attorney's office and you had just become district attorney, and I've just always been curious, tell me what you think about the death penalty, and should we keep it in America or should we not? And I know you didn't ask for this and you're on TV, but if you would tell the 2 million, if you would tell the 2 million people that are watching, what do you think? You practiced law for 40 years in Huntsville, 13 of them you were the district attorney.
And when I was district attorney, I asked for the death penalty 6 times and got it all 6 times, but they were all reversed. Back in the 70s, the Supreme Court of the United States reversed all the death penalty cases, and we had to start all over again. And I got 3 more after they killed all the 3 I had. I got 3 more, but they were all dismissed as normally is. In a death penalty case, the Supreme Court always looks at every minute detail, trying to send it back so that the person doesn't die. That's what I think, is the Supreme Court looks for every out they can to prevent a person from dying. But what do I think about it? I think that everybody feels the same way, probably, that I do. I don't want to see anybody die, and I'm not for the death penalty except if it were somebody in my family. If you kill my son, you better go to jail so I don't get my hands on you. And would I ask for the death penalty? You bet you. So I think it's a personal matter. With the more personal it is to you, the more you think about the death penalty. Is it a deterrent? I don't think it is. It is not. We've been hanging people and executing people for all these hundreds of years, and they still murder. So I don't believe it deters anybody, and sometimes I feel that being locked up in prison for the rest of your life and thinking about it and remembering what freedom used to be like is the worst punishment than death. And I know a lot of men that would rather have the death penalty than spend the rest of their life in the penitentiary. So I guess, and also they are, right now, they are having a lot of arguments, debates about the death penalty because it costs so much. It costs an extraordinary amount of money for a death case. It goes on, and you have to have highly qualified lawyers and that type of thing. So it's a real problem financially for the state. So I think they're getting more. I noticed that Governor Richardson just abandoned the death penalty in New Mexico.
Let me say this. In conclusion, I want to mention this, that about 2 years ago, when I asked you to speak on this program, Judge Joe Battle, who had been on the bench about 18 years, told me this. He said, well, I'm so glad you're going to have Fred Simpson speak. He said, during the time that I was on the bench and I was faced with death penalty cases, he said, as a circuit judge, I really couldn't make the statement that I disagreed with death penalty cases. But he said, I made sure that on every case I had, I appointed Fred Simpson to make sure that that man, I knew in that event, if he had Fred Simpson, he certainly was not going to get the death penalty. I think that's the highest compliment anybody can pay you, and I salute you.
Sure was, and thank you very much.
Thank you.
And I never lost one. Thank you very much.